All rise. The Court of Appeals, Division 1 is now in session.
Good afternoon. Please be seated. Thank you, Council, for being here today. We apologize for the scheduling issues that we've had. We're here today in 1 CV 140157 R&F Investors versus Chioli. I apologize if I've mispronounced the name. Each side will have 20 minutes to present their argument. Appellant, you may save as much time as you want for your rebuttal, but you'll have to keep track of your own time. And we have a clock at the podium to help you do that. We're recording the argument, both audio and video, and it will be up on YouTube in a couple of days, so you can be YouTube stars. We've conferenced the case and we've read the briefs, so we're familiar with the arguments. So just launch into your arguments. And before I forget, because we are recording this, please identify yourself and your client when you approach the podium. Counsel, you may begin.
Thank you, Your Honors. Libby Banks, representing R&F Investors. As you know, this is an appeal from an action to obtain a deficiency judgment after a trustee's sale. There are three main issues that we brought for review. The first is whether or not the trial court should have considered property taxes as part of the deficiency amount and the deficiency award. The second is the default interest rate and whether the trial court should have awarded default interest and when. And then the third was the issue of costs and attorney's fees. So I'll turn first to the property tax issue. In this case, we took the position in the trial court that the court should award the property taxes because defendants had not paid them. The order of information, they stopped paying in June of 2008. The foreclosure was in August of 2013, and plaintiff paid the taxes after the deed of trust sale. So
why not pay them before?
That I can't answer, and I'm not even sure that's in the record. So
because that would have simplified the analysis considerably.
It might have in this case. So, but our position is, and we believe the deed of trust requires payment of the taxes by the defendants, and the deed of trust also secures performance of each agreement in the deed of trust. So that would include that requirement to pay taxes. And so since it was secured by the deed of trust, that amount was owed under the deed of trust when it was not paid, regardless of whether plaintiff paid it before or after, because they paid it before the deficiency judgment hearing.
But, well, I'll get to that in a second. You say the deed of trust required the borrowers to pay the property taxes. What it really did, I think, was say somebody's got to pay these taxes because property taxes in Arizona are in REM. The property owes them. Somebody's got to pay them. So borrower, if you don't pay them, we lender can step in and pay them for you and then get them back from you. Is that an accurate assessment?
That is true that there's such a provision, but it does require defendant to pay them in the first place, and the the deed of trust allowing the beneficiary or the trustee to step in to pay them to preserve the security doesn't eliminate that obligation.
But the deed, correct me, but the deed of trust is no longer effective once the trustee sale happens, correct?
Well, it may have, it didn't eliminate the defendant's obligation because of the way the deed of trust is worded. The deed of trust secures all requirements, all payments, not just the payments under the note, but payments under the deed of trust, and that would include the property taxes in that
Payments
case.
weren't owed to the lender, they were owed to the state. I mean, wouldn't it be the same thing if the deed of trust had required the borrower to pay the electric bill?
But it still secured the payment of them, and plaintiff did pay them before the deficiency action was filed. So at that point,
Well, I understand, but it seems that you're arguing that there's some inherent obligation under the note to pay. Taking that as generously as we can, that there was an obligation to pay the state, that obligation to a third party doesn't necessarily translate to an amount owed to the lender under the deed of trust, unless the lender exercises the right to pay them and bill for them. Right?
again, we would just rely on that language that it secures the performance of the payment. But we do have two alternate arguments as well, one of which is that the court was required to include the the property tax liens in the calculation under the terms of ARS 33-814. The court is to use the fair market value of the property to determine the deficiency, and the fair market value is defined as the value of the property after deduction of prior liens and encumbrances.
And help me here. I understand that the taxes are fairly encompassed within that definition, but I've struggled to find anywhere in the record where that was asserted at the hearing on the fair market value calculation.
I'm having just a tiny bit trouble hearing. I'm sorry.
I'm straining to find any place in the record where this argument was asserted at the time of the Superior Court's fair market value calculation.
Yeah, it was not raised in the trial court that I could determine when I went back over.
You're familiar then with the usual result on appeal when when an issue isn't raised in the trial court. How do you get around that here?
So in my brief, I noted that this is a procedural issue, and the court has the discretion to consider this. And in addition, there is also Arizona law to the effect that the court is not limited to the parties' arguments if it would mean reaching an incorrect result. And clearly, if the statute required considering the liens on the property, then if this court doesn't consider it, that is an incorrect result. The trial court should have considered it. Since the court wouldn't consider it under the first argument, the court should have still taken it into account just by virtue of following the statute and determining how do I make this assessment.
Was there a lien on the property at the time of the fair market value?
Was there a...
Sorry, my voice is weak today. Was there a lien on the property at the time of the fair market value calculation?
Well, the taxes are always a lien on the property, and I did cite to the law in state law that provides that.
As a matter of law, that's true, but as a matter of fact, did the lien still exist at the time of that calculation?
We're looking at the fair market value as of the date of the trustee's sale. So yes, it would have existed as of the date the trial court needed to look at that issue.
And the taxes have been paid by the time of the fair market value hearing?
It was at the fair paid before then, but the court looked back to that date of the trustee's sale. That's the date that all of that fair market value is considered.
It just seems odd that if the taxes have been paid, then your client would have been aware that they were out that money and should have raised it with the Superior Court.
Well, we did raise it. We didn't raise this issue that it should be considered as a lien and deducted from the fair market value. Instead, in the trial court, it was raised as because they had paid it, the defendants owed it to them, and so it should have been part of the total amount owed. So when we're looking at the deficiency, we look at the total amount owed and the fair market value, and my position now is it should have been considered one place or the other. The court didn't consider it in the amount owed, but the statute required that it be considered as a lien against the property.
When you say when you say the amount owed, you mean the starting amount that the fair market value would be deducted from?
Right. So the total amount owed would be all of the unpaid payments under the note, any accrued interest, and then our position was that it also included the real property taxes.
So then are you arguing it was raised, it just wasn't raised in the way that we're talking about it today, or that you're talking about it today?
I would say the real property tax issue was raised. There's no question about that. And there was a ruling by the court, I believe it was in August 10th of 2013, that the court actually did rule on it. So there's definitely in the record.
What was the court's ruling on that then?
What was the ruling?
Yeah.
So that was the ruling that because they had not paid it before the trust sale, plaintiffs had not paid the real property taxes before the deed of trust sale, they were not entitled to include it in the amount owed.
Okay.
So, yeah.
It puts a fairly heavy burden on the court, though, to anticipate the need to raise issues that aren't presented to it. I mean, one might also accuse a court that does that of being biased toward one side or the other, right?
True, but
if you have a court that's asked to calculate X and they say no, you really need X plus Y.
Yeah.
I mean, what's the other side going to say? That at that point the court is becoming an advocate for one side.
But I would say that that's part of the purpose of appeal, is to give this court a chance to correct those errors, especially when they're directly opposed to what the statute provides. One of the other bases for the property taxes that we contended is that it was an unjust enrichment to the defendants. So again, they had an obligation to pay these from 2008, and so they did not pay them all of the 2008, 2009, and 2010. And plaintiffs ended up paying them with no credit towards the fair market value or the amount owed. So clearly an enrichment and an impoverishment, and they're tied together as required.
How does that differ, though, from the non-payment of the note? I mean, is that an unjust enrichment?
And so
it happens all the time.
I'm not sure what you're asking. I'm sorry.
It happens all the time that borrowers don't pay the payments, the principal and interest that they're required to pay, and foreclosures result and property goes away. But are the missed payments then unjust enrichment material?
Well, if the court won't give you judgment on as a legal matter, that's part of the grounds for unjust enrichment, is there's no legal remedy for the fact that we put this money out when the defendants were to put it out.
But as you point out, there is a legal remedy, which is the judgment for the amount owed. And if there is a legal remedy, then why would we go to unjust enrichment? Aren't we prohibited from going there if there's a legal remedy?
Are we prohibited from
going to an equitable remedy when there's a remedy at law?
I think if you don't give us the legal remedy, I think it's fair to give us the equitable remedy. So, I think there's a legal remedy. I think ARS 33814 requires the court to consider that real property tax in the fair market value. So that would be the legal remedy. But
if a party has waived or forgone that legal remedy, doesn't that necessarily necessarily preclude an equitable remedy when you had a legal remedy available, but you didn't properly use that.
I still think this court, one can consider the argument that we've raised here. And I would say again, as you pointed out, we did raise the real property issue and whether we should have some credit for it. And so if there's no legal remedy, I do think an equitable remedy would be appropriate. So I'm going to move on to the default interest issue. The court did not ever award the default rate of interest under the note. The court did, after this court remanded with a request to about the date from which the interest should accrue, the court did correct that and changed the date of accrual to the trustee's sale. So the note provided that upon the default in any payment of an installment due under the note or in any of the other agreements contained in the note or the deed of trust, that the holder could declare all sums due, and at that point the interest rate would increase by 6% from 12.25% to 18.25%.
On what amount, though?
That would be whatever the court determined was due. So we're going back to the fair market value and what's owed, the difference between those. So.
But you have to declare a default to get the default interest rate, right?
And so a default was declared a few months earlier than the August date, April 1st, 2010, when the first installment payment of $100,000 was missed. At that point, plaintiffs did initiate the deed of trust proceedings. So at that point, there was clearly an acceleration because that's required to move forward with the deed of trust sale.
Okay, but the documents here also speak to the triggering of an interest rate by a declaration of default. Is it your position then that should simply be read into the institution of foreclosure proceedings?
Yes, because there's no requirement for notice. So if there were a requirement of notice, maybe we would have had to write a letter. I would say even in that case that the service of the trustee sale documents is probably a pretty good notice that we're accelerating and moving forward to collect everything. So unquestionably, once the trustee sale proceedings were initiated, there was an acceleration of what was due, because that's what a trustee sale does, is collect everything that's due at that point. So our position is the court should have awarded the 8.25% as of April 1, 2010, when the installment payment was not paid.
But getting back to Judge Howe's question, then, is that the default interest rate on the unpaid taxes or on the unpaid principal?
That's on the total amount due, which in this case the court determined was the amount due under the note and did not include the property taxes.
It doesn't quite seem right, though. The provision says the default rate shall also be applied to the unpaid principal balance at all times that any portion of the debt evidenced hereby is past due. So the default rate goes from when it was declared past due or was actually past due.
It would be the entire unpaid principal balance, so it would be everything at that point. As soon as it's accelerated, as soon as they're saying we're going after everything that's due because you're in default, which is what you do with the trustee sale, then the entire unpaid balance and accrued interest bears.
But that's only on the debt, correct? It's not on the other things that happen to be owed because of the default.
Correct. So, and under the court's ruling, trial court's ruling, it would not include the property taxes, it wouldn't include cost or attorney's fees. It would be on the amount due under the note and any accrued interest.
And do you agree with that then?
Yes.
Okay.
Okay.
Well,
I think, if I understood you properly.
Before the trial court, it seems the parties agreed to what the amount owing was and what the interest would be on that, but then the dispute remains about whether the interest applies to the taxes, right?
So if the property taxes were included in the amount owed, then it would accrue on
they
that
weren't
as
part of
well.
the
But
debt.
if it's included in what the fair market value is, then it's not part of what's owed.
But they weren't part of the debt to the lender. The taxes were owed, if at all, to the government, not to the lender.
But again, going back to our argument that the statute requires the court to consider liens against the property, and the taxes were a lien at the date of the
Oh, yeah.
trustee's sale.
For fair market value, but the statute doesn't apply to the interpretation of the deed of trust.
Right. But it would still increase the amount owed, because if it's considered in the fair market value, it basically either one. And I have 1 minute left, so I think I should reserve that. Thank you.
Thank you.
Good afternoon. I'm Richard Hunley, and I represent the defendants and appellees, Frank and Anita Cioli. So you had it right at the beginning. I want to start with something else that wasn't mentioned. 2 of the issues on appeal have been resolved while this case was pending. It was sent back to the trial court to determine issues regarding the content of its judgment. The issues were when interest on the principal amount, or rather the deficiency amount, began to accrue and at what rate. The trial court ruled that the interest accrues as of August 13, 2010, which was the date of the trustee's sale, and at the rate of 12.5%, not the default rate of 18.5%. That ruling was filed April 20th. Neither side's appealed it. So I do not believe that before you is the issue of default interest on the principal amount of the judgment. It's not been appealed. What is before you is the question of whether the plaintiff could assess default interest on the unpaid property tax. There are 4 issues here that are related to the property tax, and there's a couple problems with what the plaintiff is trying to do. Because as the court noted, the plaintiff is trying to have the court rule on issues that weren't raised at the trial court level, and without a transcript of the trial to see what actually was offered, what was testified to. Now, the property tax issues, the first 2 contentions arise from the resolution of defendant's motion for summary judgment prior to trial. Issue 1 was whether the defendants are liable for default interest at the 18.5% interest rate when they fail to pay property taxes starting, I think, in June of 2008. And the answer to that is clearly no, because under the deed of trust, if the defendants do not pay property tax, which is a debt owed to the county of Maricopa, it's not owed to the plaintiffs. If the defendants don't pay it, the plaintiffs have the option of paying it on their behalf. And then the deed of trust in its paragraph 5 says the defendants then must immediately reimburse the plaintiffs. The plaintiffs, or its plaintiff's predecessor in interest, did not advance and pay these property taxes. Therefore, the duty for defendants to pay plaintiff didn't arise. Therefore, there's no default, and no default interest rate results. Also, on this issue, plaintiffs contend that the amount of the unpaid property taxes should have been added to the loan balance. Now, we're talking about these property taxes as if we have some solid evidence of them. They were alleged in plaintiff's complaint to be about $70,000 or so. But we don't have the record of trial. We don't have any evidence that this amount was actually presented to the trial court. There's nothing that they can point to in the record or the exhibits.
So, the trial court didn't rule that the property taxes were not part of the amount owed?
Yes, the court ruled that the property taxes could not, the non-payment did not trigger the default interest rate, whatever amount your property taxes were, and the failure to pay the property taxes, the taxes would not be added to the loan balance, whatever amount that was. And again, for the same reason, under the note and deed of trust, defendants were only liable to plaintiff to pay the property tax if plaintiff paid it on their behalf, and plaintiffs did not do that.
just so I'm clear, do you agree that had plaintiffs raised it to the trial court to say that the taxes, were a lien or an encumbrance on the property that should be taken into account in determining the fair market value? Would you agree with that?
I would agree with that. I would agree that the statute says that senior liens are to be considered in determining the fair market value.
And I realize it's not exact, but what's the difference in coming to the amount in the deficiency judgment if you consider it then, or if you consider it up front in the amount owed?
Well, mathematically, it might balance out that way, but the way the statute reads and the way the deed of trust reads, the property tax isn't added to the note balance unless the lender actually pays it. If the lender doesn't actually pay it, it can still be addressed in the fair market value determination because it's a senior lien.
And it should have been.
And it should have been, but the problem here is we don't know if it was. We don't have a record to show whether the experts considered the property tax in giving their opinions. We don't have a record to show if they were asked about this at trial. We don't have a record to show that the experts would believe that the amount of unpaid property taxes would or would not affect their opinions, and if so, to what amount?
Well,
We just don't have
What
that.
expert is going to say that a big unpaid property tax bill doesn't have an effect on fair market value?
That's right. That's right. So
it
with-
would have. I mean, I think we can. The legislature effectively took notice of that fact when it included this in the fair market value calculation.
That's right. We had
That's
two-
not a discretionary art. That's dollar for dollar.
That's right. And we had two experienced appraisers who gave their opinion of value, and the plaintiffs can't show that they missed it. There's nothing before you to say, well, there are two experts. The court went with defendants as more persuasive. Plaintiffs have nothing to say that the amount of unpaid property taxes wasn't built in to the fair market value valuation that we presented.
So you're not just claiming that it was waived. You're claiming that it may not have been waived and they lost.
Right.
We don't know. Okay.
Right. Is the plaintiff in doing that? I mean, well, that's really the third issue on the unpaid property taxes, and that's the issue that I believe was waived. Counsel in their last brief and briefly in the argument said that this is a procedural issue, and I disagree very much. This is a fact-based issue. The issue is, what is the amount of the unpaid property taxes? Do we have a record to show that that was part of the trial consideration? If so, was it considered by the appraisers? Were they questioned about it? Was it factored into their appraisals? It's a fact-based determination, so since it wasn't raised at trial, it's waived, but I think it was covered in the appraisals that were given to the trial court. The fourth area where the property taxes are at issue here is that the unjust enrichment issue, the unjust enrichment claim. The lender did not pay the property taxes prior to the foreclosure sale, so the lender foreclosed in August 2010. The lender then transferred title to the plaintiff. The plaintiff, about a year and 3 months after the foreclosure sale, paid the property taxes. There's no unjust enrichment there because, number one, the obligation for defendants to pay the property tax arises from the deed of trust, which by law was extinguished when the trustee sale took place. And number two, because individuals are not personally responsible for property taxes. To have unjust enrichment, there has to be some benefit, some wrongful benefit that somebody is getting, like the defendants here.
What about possession of property?
Well, they lost possession of the property.
Years after they stopped paying the tax.
That's right.
So wasn't that a benefit to have the property tax-free during that time?
Well, no, because under that, the deed of trust controlled, and the plaintiffs could have paid it, and then the defendants would have to pay them back. But what the payment was made post-trustee sale. The defendants, this was not an obligation that would follow the defendants around personally. It just would attach to the property. So there can be no unjust enrichment there. The defendants were not unjustly enriched in November 2011 when the plaintiffs paid the property tax because the defendants didn't own the property anymore. They lost it about a year and a half earlier.
A year and a half earlier being 2010.
Yes, they lost it in August, not a year and a half, year and 3 months earlier at the August 2010 foreclosure sale.
Yeah, but from August 2008 to 2010, they were just enjoying tax-free property.
Well,
Would be great. I mean, we'd all like to do that, but
right, but the payment wasn't made in that time. If the payment was made during that time, then the defendants, it wouldn't be an unjust enrichment claim, it's a straightforward contract claim. They would be required to pay the property taxes to plaintiff, or plaintiff could foreclose. If the deed of trust didn't have that language, and the plaintiff paid the property taxes between June of 2008 up through the foreclosure sale, then you probably would have an unjust enrichment claim. But the plaintiff didn't pay them. Okay. The other issues that the plaintiff raises, I think, that primarily go to the attorney's fees and costs that were awarded by the trial court. Those are purely discretionary issues. The trial court's given great discretion. It first arises in the cost award. The plaintiff wanted over $8,000 for their expert fee for their appraiser. That is not something that's recoverable under the statute 12332. Plaintiff says, but in the note it says we get to recover attorney's fees and, quote, all costs, close quote. Well, the trial court, by case law, is entitled to determine what that means and what costs are awardable under all costs. This trial court determined that it would not include the expert fees, and there's no suggestion that there's an abuse of discretion here. Also, on the attorney's fees issue,
expert fees all costs.
well, under Arizona law, expert fees are not considered awardable costs. They're something different. The only time they're statutorily awardable is in medical malpractice cases, and that's limited, I believe, just to the time of testimony.
well, why are the statutes important if you have a contract?
It says all costs.
Right, because the note says all costs. Well, the typical understanding of cost does not include expert fees.
Well, the understanding of costs is different at an appellate court from a trial court.
Well, we have a vague contract that says all costs. If the trial court said all costs includes expert fees, I'd have a problem objecting to that.
Well, but
because
we
it's,
have two statutes, right? We have 12331, which governs costs at the trial court. We have 12332, which governs costs at the Supreme Court. And for some reason, we don't have any statute that governs costs right here in this room. But which one are we supposed to use? If you're claiming that the contractual definition is governed by statute, how do we pick among conflicting definitions?
well, no, I'm not quite saying that. I'm sorry if I missaid that. The expert fee is not recoverable by those statutes that you mentioned. The trial court has to determine what reference to all costs in the note means. And here the trial court seems to have determined that it does not include expert costs. And the case law says that the trial court can make that determination within its discretion. And perhaps one of the factors that the trial court is determining is the use of costs generally refers to the items that are mentioned in the statutes. Because of that, there are certainly contract provisions you probably all have seen, which will say that you can recover all costs, including experts' costs. But we don't have that here.
Sure. And I've also seen rules, Rule 68 being an example, or I think it's 76 in compulsory arbitration, that allow for expert fees as recoverable costs. I mean, it seems to me that the definition, if you're trying to tether yourself to some external abstract legal definition, they're all over the place.
True.
And so when the drafters of the contract say all, shouldn't we be as expansive as possible to fulfill the meaning of the word all?
Well, but does all costs mean lunches, travel, things like that? And if you are giving the experts fees, is it for time of testimony, time for giving the opinion? I mean, here it's like $8,000, of which $7,500 or so was to, look about it and think about it and draft a report. There was only minimal testimony.
Does the contract reference the statutory definitions of
Nope, all it says is all costs.
As in the non-legal context, would all costs mean all costs, including?
I think the trial court is allowed to exercise its discretion when you have something as vague or as unspecific as that to determine what costs are included. The trial court has to award some costs, but it can determine what are all costs. And here again, this is an expert that the trial court found not to be persuasive also, so that might have weighed in the court's opinion.
Those are tough definitions.
They are.
Just say that.
They are.
If
The
you
statutes
read
are vague,
1230
and the contract was vaguer.
If you read 12331 literally, the filing fee isn't a taxable
That's right.
cost.
There is something in another statute that makes a cost something that a court requires you to do. So in a lot of cases, that's what allows litigants to get their filing fees.
There's a Court of Appeals decision too. But
Okay. There was also the attorney fee issue, and I got a couple minutes. The plaintiffs asked for about $54,000. They were given $36,000. The trial court did not explain its ruling. The trial court obviously adopted defendant's position as to the amount, although not exactly. The plaintiff contends that this did not include Attorney Barry Reese's fees. Well, the trial court got it right on this point. Barry Reese was a member of the plaintiffs. R and F investors, R is Reese, F is Frankel. They're two guys who have this LLC. Mr. Reese was representing the entity through himself for a while until he retained other counsel. The trial court, if its decision was to not allow Mr. Reese's fees, got it right, because while Mr. Reese may have done the work, he didn't satisfy the statutory requirement in 1234101, which concludes with the fee award cannot exceed the amount paid or agreed to be paid. There was no evidence provided to the trial court that R and F investors in effect paid Mr. Reese, or that Mr. Reese paid Mr. Reese to do work on Mr. Reese and Mr. Frankel's behalf. So those are attorney's fees that could be rejected. It's not a typical situation where the attorney is representing some third party and is billing and getting paid. Here the attorney is part of the plaintiff, and there was no evidence that he was being paid for his services. So I believe the trial court got it right, and what we ask is that the trial court's decision be sustained. And unless there's any other questions, I'll rest.
Thank you, counsel.
Thank you.
And counsel, I think we asked you quite a few questions, so if you want an additional minute, that's fine.
Okay, I'll make my points fairly quickly, thank you. As far as the taxes, the amount was presented to the trial court during the hearing where that was requested. And in the court's minute entry, the trial court actually rules on what those costs were. So it's actually in the minute entry. So clearly it was before the court, and the court ruled on that. The issue of whether or not the record shows whether that was considered by the appraisers. Documents number 79 and 83 in the record show that neither of the appraisers considered the unpaid taxes when they established their value. That's their depositions.
I'm sorry, what exhibit was that?
Documents number 79 and 83. Those are the depositions and the appraisal packets from each of the experts, and neither of them considered that at all.
Isn't that really odd? The two people whose sole purpose in life is to appraise real estate didn't look at the taxes?
They likely weren't asked to, so that would be part of it.
Doesn't that sort of support the notion then of a true waiver? Because that's not the kind of thing. You're asking us to reverse a trial court for not intuiting what a party would have wanted under the statute, but you've got two experts who do this all day, every day.
You know, and I will say again, the taxes were paid after the trustee sale, so their appraisal may have looked at that and determined that it wasn't part of it. And then I would say the minute entry of the court shows that the court did not consider that either. Attorney's fees are not discretionary when they are contractual. And as to the costs, the statute for ARS 33814 and the contract both say any costs, all costs, and they don't refer to the cost statute as a limiting factor. So, thank you very much.
Thank you, counsel. And thank you for your arguments. We'll take this matter under advisement and issue a decision in due course. We stand adjourned.